If you're not happy with decisions made by Ohio's lower courts, your appeal could be heard by the 7 justices who sit on the Ohio Supreme Court here in Columbus. Their rulings affect the quality of life of every resident of the state. Now, 3 of those 7 seats are being contested this fall. In one of those races, Republican incumbent Terrence O'Donnell is being challenged by Democrat Mike Skindle. The year was 2003 when Justice O'Donnell joined the court, but he began his judicial career in 1980 on the bench of the Cuyahoga County Common Pleas Court in Cleveland. He's also a former high school teacher who once chaired the Ohio Civil Rights Commission.
Ohio currently elects its judges, but many people feel they should be appointed by the governor or a nonpartisan committee. What do you feel is better for the community and why?
Well, I think in regard to the manner of selection of judges, I don't know that we have any 2 states of the 50 that do it exactly the same way. I can tell you that in 1987, the question of whether or not we should have merit selection as opposed to election of judges was posed to the electorate. And at that time, the cry was, don't give up your right to vote. Don't surrender the right you have to elect public officials. That measure went down to defeat in Ohio by a 2-to-1 majority. As a practical member of the judiciary who has served for more than 32 years as a judge and been involved in, this is now my 11th election, I think that we have formulated a system where the public can be involved and the public can have its say in which individuals ought to be serving in high office. The role of the judiciary is an important one, and we permit judges to go to the public to describe their background, their qualifications, their experience, and their education in order that the public can find out which candidate is best able to serve in that role as being an impartial, open-minded, and fair jurist. In that regard, I can tell you, I have been educated at St. Edward High School in Lakewood, Ohio, Kent State University, and received a law degree from Cleveland State University. I've served for 14 years as a member of the Common Pleas Court in Cuyahoga County, tried virtually every type of case, civil, criminal, complex litigation cases, and I had the privilege to serve an additional 8 years on the 8th District Court of Appeals, the intermediate reviewing court for the work of all the trial judges in Cuyahoga County, the busiest trial court county in the state of Ohio. I now am here in my 10th year serving on the Ohio Supreme Court. I consider it a great privilege and a great honor that I have had to serve in this capacity, and I offer that experience as an indication of the level of public service that I've offered to the state of Ohio and hopefully continue in that capacity.
If you're elected as justice, will you make your decisions based on your political affiliation or what you feel is best for the people of Ohio?
Connor, your question bespeaks the understanding of the role of a judge. The canons of judicial ethics, the code of judicial conduct, tells us that judges don't make decisions on personal preference nor on political decision-making. Rather, judges take an oath to support the Constitution and the laws of the state of Ohio. Judges must screen out personal and other influences and make decisions only on what the facts are in the case before them and what the law is. And over the years of serving as a common pleas court judge for 14 years, an intermediate appellate court judge for 8 years, and now serving in my 10th year as a member of the Ohio Supreme Court, I have trained myself to studiously study the record, to determine what the facts are, and to apply the law to the facts of the case in order to reach a decision. And that process is what instills public confidence in the lawyers and litigants who come before our court, because they know that they can rely on what the law is as promulgated by the General Assembly and as interpreted by the court, not changed by the court, not applied in a way that one jurist would like it to be, but rather the way it was written by the General Assembly. And this instills confidence in our system of jurisprudence and creates order in our society. That's the manner by which I have adjudicated cases for 32 years, and if elected, it is the manner by which I will continue to decide matters that come before the Ohio Supreme Court. Thank you for the question.
There seems to be a philosophical difference of viewpoint on the court about the punishment of juvenile offenders. In your opinion, should juveniles be treated differently from adults in all cases? Do you believe there are some punishments that are just too harsh for juvenile offenders?
You know, Marianna, that's a great question, and I appreciate you bringing it to our attention. Your question goes to the policy of the state of Ohio, and I think what you recognize is, and maybe the public is aware, that the role of the courts is to simply interpret statutes, not to make statutes. Judges do not express personal opinions. Judges don't adjudicate personal preferences, but rather, judges are bound to follow the law. The question you pose is, how should we be treating juvenile offenders? Well, as you know, and as many are aware, juveniles who are involved with the juvenile court system are not committing criminal offenses, though if committed as an adult, they may be. Juveniles, rather, are adjudicated delinquent or unruly and are treated with a different outlook. The whole concept of the juvenile court is to try to rehabilitate the offender. The concept is to try to ameliorate living conditions that might be adverse and contributing factors, and try to make life better for that individual. And in that regard, I don't think we need to dramatize or criminalize these kinds of actions. I think our system is working well, and we need to be sensitive to current changes in that regard.
Many people feel that justice is for sale in Ohio due to the influence of campaign contributions to Supreme Court justices. How can you assure all Ohioans that your decisions will be fair and unbiased in light of the fact that you're receiving campaign contributions from interest groups that expect you to vote their way?
You know, the question comes up perennially about the influence of campaign contributions in court decisions. Our court is responsible for the presiding over and making the rules for the conduct of all judicial elections in the state. We have limited the amount of campaign contributions that can be made to a judge's campaign. We have precluded any judge from accepting or soliciting campaign contributions directly from a donor. The interface then of the committee and the judge acts as a barrier. We have told the campaign contributions are to be made to a campaign committee, not to a judge. And the reality is, and sometimes I think the public doesn't understand, that these are not dollars that come to the judicial officer or the candidate for judicial office. These are dollars that go to a campaign committee and are then funneled to major media, television, radio, or newspaper advertising, to advertise the qualifications, the background, and the experience of the judge. The voters in Ohio desperately want the opportunity to vote for candidates for judicial office. We know this because in 1987, there was a movement afoot to change the Constitution of Ohio and remove the elective authority of the voters to elect judges and move to a merit selection system. That was resoundingly rejected 2-1 in our state. So we know that the voters want the right to vote, and we think that they have the right, and the candidates have the right, to advertise their qualifications and experience so that the voters can make intelligent choices. By limiting the size of the contributions, by having a committee charged with promulgating the expenditure of those funds, we can best educate the public as to the qualifications of candidates for judicial office. I might add that this is the 11th time I've been before the voters. It's the 4th time I've been a statewide candidate since 2000. I'm privileged to have a 32-year judicial career, and I'm privileged to be serving in my 10th year as a member of the Ohio Supreme Court. and I hope to continue to have the opportunity to instill public confidence in the decisions of the Ohio Supreme Court. Thanks very much for the question.
There's been a lot of discussion lately about judges legislating from the bench, effectively rewriting the laws that the legislature has previously written. How do you feel about that issue?
Well, I guess my answer to that kind of a question is that the role of judges is to interpret the law, not to make the law. I believe strongly in the concept of separation of powers, what we learn in 5th and 6th grade about the origins of our Constitution and the roles of the 3 branches of government. The legislature is the lawmaking body, the executive department is the enforcement agency, and the judicial role is to interpret laws. And I have built my 32-year judicial career following that philosophy in making case decisions. I do not think judges should be legislators. The policy-making branch of government is the General Assembly. The role of the court is to simply interpret the laws as promulgated by the General Assembly.
As a Supreme Court justice, what would you do to ensure that people in poverty, people that are underrepresented or otherwise disenfranchised, have equal access to the justice system?
Access to justice is an important concept and one that the Supreme Court of the state of Ohio has taken up, particularly in our administrative sessions as we have had the opportunity to get ourselves involved with this issue. We have regulated, for example, costs. We have dealt with the foreclosure crisis on a direct basis, making available counsel to those who otherwise don't. We have promulgated pro bono work and encouraged lawyers across the state of Ohio to engage in pro bono work for those that might otherwise not be able to find a lawyer. We have broken down language barriers. I was privileged to serve on the Ohio State Bar Foundation in a special project for the Somali population in Franklin County, where we reached out to that population to bring them in and make that more accessible. We've also worked with interpreters, and we have a program available where those who don't speak the language are able to find those who are certified and qualified to assist them when they have legal matters that come before the courts of our state. So I believe that you have lighted upon what I regard as an important issue of access in Ohio, and I'm very pleased to tell you that it is one of those that is on the radar screen of the Ohio Supreme Court, and one with which we are dealing on an active and regular basis.
During the campaign, voters will be asking you a lot of questions about specific issues. How will you answer these questions so that voters will have the information they need when they go to vote without violating the Judicial Ethics Code?
Victoria, that's a great question. I can tell you that there are no issues in judicial campaigns. The only matters for voters' concern is the background, the character, and the integrity of the individual and the experience that person brings to the office. In that regard, I can tell you that I was graduated from St. Edward High School in Lakewood, Ohio. I graduated from Kent State University and learned a law degree from Cleveland State University. I served as a law clerk on the Ohio Supreme Court right out of law school and followed up with clerkship experiences at the 8th District Court of Appeals with Judges John Manos and John V. Corrigan. I practiced law for 6 years, tried numerous cases of every kind and variety, and then in 1980 I took a position on the Common Pleas Court. I have been a Common Pleas Court trial judge in the busiest trial court in the state, Cuyahoga County, for 14 years. I served 8 additional years as an intermediate appellate court judge on the 8th District Court of Appeals, and I now am before you in my 10th year as a member of the Ohio Supreme Court. This is the experience that I bring to this office. Point out that my opponent has never been a judge. He's never charged a jury. He's never presided over a trial. And he lacks that kind of experience in making decisions on matters without that kind of judicial experience. Short answer to your question is, we don't comment about any matters that are likely to come before the court so that we can maintain impartiality and fairness and keep minds open as to the correct determination to be made in those cases. Thank you very much for that question.
When it comes to sentencing, which do you prefer, judicial discretion or minimum mandatory sentencing?
This is not a choice for a judge to make. The policy-making branch of government is the legislative branch, and it is the legislature that determines the appropriate sanction for breach of a criminal statute. In that regard, I have had the privilege as a common pleas court judge in Cuyahoga County to preside over numerous criminal trials in a 14-year career there. I have had the opportunity to sentence literally thousands of individuals in the state of Ohio. And in doing so, some of those cases required a mandatory sentence, and some of them vested discretion with the trial court to impose a period of probation or graduating degrees of incarceration and/or impose fines. Sentencing is a difficult area for judges. Ohio does have capital punishment, and on occasion, I have had the opportunity and the duty to impose it, and I've done so. I don't take the role of a judge in imposing sentence lightly, but your question goes to whether or not the judge has a personal preference as to what it is. Keep in mind, every judge in the state of Ohio takes an oath, and the oath is to support the Constitution and the laws of the state of Ohio. And in doing so, judges don't have the option, if you will, to change the law or apply their own conception of what they think it is or what they want it to be. No, judges, like others, are bound to follow the law. And as the legislature sets the policy, it also prescribes the punishment for breach of criminal statutes. And it's the oath and duty of judges to impose that law and not to express their own opinions about what changes they want or what they would like it to be. So I have built a career by following the law as directed by the General Assembly.
We still have a foreclosure crisis in Ohio. It's been 5 years since the Supreme Court took the initiative to encourage attorneys across the state to represent homeowners in foreclosure cases and also to set up mediation programs in the counties. What will you do to review how that process has worked and to strengthen it going forward?
Well, as you know, I've been one of the members of the court who was instrumental in formulating and bringing that program to fruition. So I'm an advocate that we make available lawyers to those who need that service. And it isn't just legal aid lawyers. We have lawyers from virtually every law firm around the state of Ohio who have volunteered their time and are willing to assist those in need. I'm committed to that type of program. I'm committed to having lawyers participate in pro bono activity, not just foreclosure, but in a number of other areas, and am a proponent that this kind of activity be encouraged.
The office of the Ohio Supreme Court is a highly influential position. I'd like to know 3 things about justices who are running for the Supreme Court. Number 1, what has been your greatest accomplishment in administering justice? Number 2, what has been your opponent's greatest accomplishment in administering justice? And number 3, what has been the Ohio Supreme Court's greatest accomplishment in administering justice?
Well, thank you for the question. We don't often get to talk about things that we do on a personal level because, as you know, as a member of the Ohio Supreme Court, I'm simply 1/7 of one vote on every case. It's an important court, you're correct, because the decisions of the Ohio Supreme Court are binding on all 730 judges who serve in our state. On a personal level, in response to your question, I'm very proud to have played an instrumental and founding role in a program that we now call lawyer-to-lawyer mentoring in Ohio. You're probably aware that Ohio has 50,000 lawyers, and every year, through the admission of new lawyers and those who are successful in the bar examination, we admit somewhere in the range of 1,500 new lawyers. Many of those are not acquainted with law firms. They're not working directly for larger law firms. And I have been instrumental in pairing up experienced lawyers with the newly admitted lawyers in a mentoring program where they get together on a regular basis and talk about legal issues. Our Professionalism Commission has been instrumental in making this program successful, and I am proud that I have had a role in getting that program off the ground and being a force to keep it alive. I've been privileged to speak on topics of professionalism and ethics around our state, and I've been asked to attend conferences out of state and address this mentoring program concept, which is being emulated around the country. As far as the role that my opponent has in implementing judicial change, he has none. He is not a judge. He has never served as a judge. He has never tried a case as a jurist. He has never served on an appellate court, and he has never had any capacity to serve on the Ohio Supreme Court. My opponent is a state legislator, and I'm sure accomplished in that regard, but has absolutely no experience in the judicial role as a common pleas court, court of appeals, or Supreme Court justice. And then when you talk about the accomplishments of the Ohio Supreme Court, I'm very proud to serve on our court. We have instilled public confidence in the decisions of our court, and I can tell you that the Supreme Court has a role in our nation, and people look to decisions that have been rendered by our court and wonder on the same question in a sister state, what is it that the Ohio Supreme Court has said about this topic? And the national reputation that Ohio has is a tribute to the members and my colleagues who serve on the Ohio Supreme Court, and I'm very proud to be connected with them, and I'm very privileged to be a member of the Ohio Supreme Court. My name is Terry O'Donnell. I'm a justice of the Ohio Supreme Court, and I'm a candidate for re-election this November. I'm asking for your vote based on my judicial experience. I've served for 14 years as a member of the Common Pleas Court in Cuyahoga County, and following that 14-year period on the busiest trial court in the state of Ohio, I had the privilege of serving for 8 years on the Intermediate Court of Appeals in the 8th District Court of Appeals. In 2003, I began my service on the Ohio Supreme Court, and I stand before you as a candidate for re-election to the Supreme Court. And I'm now serving in my 10th year as a member of the Supreme Court. I can tell you that it's a great privilege to serve in this capacity. It is an honor to have the privilege of serving for 32 years as a member of the state judiciary. And as I offer my campaign experience, my judicial experience in this campaign, I would ask respectfully for your vote this November. Thank you very much.
If you plan on casting your vote in person, make sure you know the ward number and the precinct number of where you're supposed to vote. Tom McKee, 9 News at the Ohio Supreme Court in Columbus.